Thank you all for being here. I know that law for most people is kind of a snooze fest, but I'll try to keep it as lively as possible this early in the morning. So a little background on me. My name is Christine Taylor. I used to be Christine Renard. My parents have owned 3 campgrounds. They've owned 2 KOAs. They bought their first campground when I was 9 years old. It was the other franchise, and they did that one for a while. I got to dress up as some costumed characters, and that's kind of how I got my jump into the campground industry. So when I talk about campgrounds, I talk about it from a good, better, best perspective. I'm telling you the law, what I'd love for you to do, and then I'm going to tell you that there's kind of a middle ground that I'd prefer over nothing, because I know, money is a factor in these things. And then there's the please do something category. So when I came home from law school, I, a freshly educated lawyer, told my parents everything that they were doing wrong, which was a lot of things, because we have a history in the campground industry of kind of skating under the radar previously from both governmental bodies cracking down on us and from other pieces. They'd attack big hotel chains, but they kind of ignored campgrounds. Now, some of that is changing. So when all of this kind of came to a head was kind of last year, which we saw with COVID and all of that. And because employment and unemployment took a little bit of a change, my prediction in the spring was that I was going to start seeing a lot of employment cases and a lot of employees turning in employers because, for better or worse, they think you guys as business owners have really deep pockets, not understanding there's not so much liquidity in the industry. However, it is something that I see happening, and there are quite a few things to touch on today. So I'm a very fast speaker, and I apologize, but I want to try to cram as much information for you as possible. Please feel free to raise your hand if you have a question while we're going, and I'll try to get to it.
I have a question.
Yeah.
Will your slides be on, will they be sent out so that we don't have to write us because we can't?
I hope so. Did we send them? We sent them in, right?
They did not take them, but we can.
I will send them to someone who has your, I don't have all your emails, but if you want to, I can give you my card. You can shoot us an email, and I can forward it to you, just in case that KOA doesn't. All right. Number one thing we're doing wrong is volunteers. How could you do volunteers wrong? So what is super wonderful is Camper Sally. She loves recreation. She grew up in your campground. She loved playing kickball. You're like, cool, help me out now. You throw her a staff shirt, and she runs the game. She's volunteering to run the game. Is this a problem? Likely. So the really fun thing is that this implicates both state and federal law. So in general, a person can't volunteer for a for-profit employer. So because you're not a not-for-profit, you are legally not allowed to have a volunteer. So if you I know, good morning. So volunteers are technically illegal. Now, we had a ton of volunteers, especially in rec. And because that was a low-cost way, people got excited about helping about it, but because they were volunteers, it was technically illegal. So under federal law, the Fair Labor Standards Act, for-profit employers, which is what you are, you're making money for you, must pay employees for their work, and they cannot volunteer. Now, some people approach me and they go, hey, what if it's an intern? There are very specific tests to examine the economic reality of the relationship to determine whether they're an intern or not. And if you're going to do an intern, and there are some people who've successfully done this, they've partnered with a local community college or something like that to create a whole intern program in which that specific intern is meeting these education requirements such that they get educational credit towards their degree. Now, that's like a really big deal, and I know that most campgrounds aren't going to go through that process, but if there's some way you still want volunteer labor, that really is kind of the only loophole. So, volunteers, illegal. It's definitely at a federal level, so that applies to everybody. What if you do it anyway? So I had a man approach me in the spring, and he goes, hey, I've owned my campground for 42 years, and I've done this whole time. And I said, that's perfectly, that's true. A lot of people have done this whole time, but it's still illegal. So if that employee, volunteer, gets hurt, or if they get mad at you and they report you to your Department of Labor, that is when you can get hit with all of these fines, have to pay them for all the work and overtime work that they did for you, suddenly get implicated at the federal level for the taxes, payroll taxes, workers' comp, all of these things that because they were a volunteer, they now narked on you to the higher people and you're suddenly having to pay a bunch of fines. Ultimately, it would have been cheaper to pay them as a paid employee than it would have been as a volunteer. Now, I told that story in the spring to a room full of people, and there was one such woman who goes, this totally happened to me last summer. They reported to me, she's like, I'd never have a volunteer again. Never, ever, ever. It cost her too much money ultimately, so now that's soured for her. But like I said, conversely, I know a lot of people, especially campgrounds, it's very hard to find labor, especially if you're in a seasonal climate like the Northeast where you only have seasonal labor. So a lot of people plugged some gaps with volunteers, seasonal volunteers, overnight camper volunteers, but be very, very careful because when the employment kind of winds change, as they have been, as we've seen, I mean, half the things aren't open anymore because you can't get employees. It's an employee market right now, and people have found and become more educated that there are certain things that they can do. Full disclosure, there are online forums where people are now spreading information about how to go after their employers. They're called like anti-work forums, and I've seen them and kept an eye on them because they're now kind of being like, well, if they weren't paying you correctly, you could report them. So do keep that in mind. All right, the next one that's a problem is a lot of people tell me they have an independent contractor relationship with people. Sam, he cuts that grass and he does the landscaping on your property every Wednesday. That's when you told him he had to. He has to be there every Wednesday. You provide the equipment, but you pay him with a 1099. Not an independent contractor. Mary runs ceramics every other Saturday. She brings everything. She picked Saturday. I just give her the space to do it. She picked that day. I pay her with a 1099, an independent contractor. Now, what made them different? Well, there's a lot of tests versus where someone is an independent contractor or not. And calling them an independent contractor and paying them with a 1099 doesn't make them an independent contractor. You have to also satisfy all of these tests. And you, as the employer, are responsible for correctly classifying your workers. So you might be like, they told me it was an independent contractor relationship. It doesn't matter. You, as the person employing them or engaging their services as an independent contractor, are responsible for making sure they are actually that particular kind of employee or independent contractor for you. And unfortunately, there are lots of severe penalties with anything, and misclassification, especially in some states, is a really, really big deal. So we start at the federal level. The IRS has its own test about whether or not somebody is an independent contractor. So they do a 3-part test, and it's basically the word of the day for independent contractors is control. So there's behavioral control, which is, are you telling them what to do? Are you dictating their behavior and how they do it, or do they get to do it on their own? Did you train them about what you wanted? So going back to that landscaper, if he's like, I landscape a bunch of homes and I also come and do your property, and he does it whenever he gets to it, and he brings all his equipment, and you just were like, I need the grass cut, and it's all on him, that's more like an independent contractor. If you are providing, that weed eater, that edger, that backpack blower, and you're telling him he has to be there on a certain day, and you showed him how to do it, he's really more likely an employee. Then that goes into the financial control. Did they invest in that equipment? So since it's their own equipment and their finances are their business and what they use, that's all of their expenses, it's more likely they're an independent contractor. Once you start providing things to them, if you reimburse them, say they bought gas for the equipment and you gave them money back, they no longer are in charge of the financials by themselves, such that you still have financial control, so they're still an employee of you. And then the type of relationship. So is it for a set period? Are they a key aspect of the business? Now that one gets a little crazy. The key aspect of the business I find very strange. So the best thing that I could come up with is if you have a check-in person that basically nobody's gonna get checked in unless that person is there. They're very key to your business. Your business cannot operate without them. They're not an independent contractor because your business fails without them. So those are kind of the IRS tests. So we're just talking the federal level, just the IRS for that. So Some states adopt these tests themselves, and we have a handout we can also pass around where we did some 50-state research, but you'll see some of these go through. So states have adopted different tests for different parts of their system for employees. So the states that adopted that test include Indiana, Rhode Island, and Virginia. So if you're looking for what the state might feel about that, in those states, if you're meeting the IRS test, then you're good to go at the state level. Okay, so again, I said control's kind of the name of the game. You're going to see that there's all of these tests, but really when it gets down to it, it's some form of control. So the next one they call is the right to control test. Yep. Sure.
What if, say, in your individual contractor, they provide their own tools and equipment? Say if they're on your site, and you're not providing them the equipment, but say if they didn't have one on site, and you loan them, say, circuit saws on it.
So you're getting to gray areas. This is what I talk about. There's a good, better, best. So technically, if everything else is okay, I think about it like if someone hauled me in front of an admin board or hauled me in front of a court, could I say, this was a one-off and they just really need something and I helped them out? Likely still an independent contractor. If it's, well, I know that Bob has a weed eater and I'm not going to even bother and use his every time, then you're going to start tipping more towards there being an issue. But again, if it's one piece of equipment and the rest of their job's okay, and the financial control piece is okay, and everything else is okay, it's likely not enough to tip the scales to being in trouble. Yeah, absolutely. So the right to control test is very similar. It determines whether an employee has the right to control the time of work and other factors to determine if they are an independent contractor. So a lot of states use this right to control test. So I'm not going to list them all. I don't think you need to hear me say states. But a lot of states do this. And when you see the parentheses, it's because they use this test for different parts of their law. So Alabama, for example, uses this test just generally. They look at control. It's going to look at all those things. It's very similar to the IRS test. They just call it something else. Connecticut, for example, when they're looking at whether or not you should have gotten workers' comp insurance for those people, they'll be looking at the right to control test, but not generally for all of their stuff, so to speak. And then Michigan, for example, looks at it for whether or not you'd have to pay unemployment for them if they stop working for you. So that's how those states use that right to control test. Ultimately, it's very similar to the IRS test. I have no idea why states decide to peel out different pieces, but you'll see it gets a little nitty-gritty. And that's partially just because that's our legal system in this country. We have the federal level and we have the state level, and states are allowed to do their own thing, and that's how we end up with some discrepancies between the states. Okay, so the next thing is the factors test. Wow, this sounds really similar. We had right to control, which had factors that they considered, and now we have a factors test, which, holy moly, there's a lot of factors. There's 3 to 20 different factors a court must consider when determining if someone is an independent contractor. Most of these, again, are like the IRS test. Like, intuitively, it feels very similar. They've just specifically delineated all of these different factors such that you can go through a checklist. So if they are considered an employee, then the individual must be paid at least the minimum wage and sometimes overtime. So as I said, a 1099 does not automatically make someone an independent contractor at the federal level. They look at those factors. When do these factors not matter? If there wasn't a formal agreement, it doesn't matter when we're talking about method of pay, if you gave them a check, if you gave them cash, etc. It doesn't matter where the work is performed. So if you're like, it was performed at my business, so they're obviously an independent contractor, or it was performed over here in this thing, they don't care. They're still going to read the other things onto it, and they are not going to care if you satisfied another level of independent contractor. So if you're like, it's cool, I did it at the state level, and they're like, no, you still failed the federal test. Or I met the federal test, and they're like, no, you still failed the state restrictive test. So you might be okay with one body of government or, one specific level, but that doesn't get you off the hook with the other one, which is kind of annoying because you're going to have to check all of these different boxes to make sure that person's an independent contractor. I'm sure you're sitting there right now and you're like, I'm never going to have an independent contractor. This is way too daunting. It really is pretty daunting. So unless you're exactly clear and you've been doing it, that's okay. I was at RVIC last week, and I had this conversation with a woman over breakfast. Yes, 8 a.m. father. It's super, super entertaining. And she actually was doing all the independent contractor things correctly. She had set it up with her accountant. They had met all the requirements. She was essentially letting those people not run willy-nilly, but do whatever they wanted because they were independent contractors. So there are some people who have figured out how to do it. So it is something that happens. But conversely, I have a campground, and I have told him multiple times that his independent contractors are not independent contractors, and nothing has happened to him currently. He's still taking that risk, but I know, and he knows, that they're not really independent contractors. Now, if that independent contractor never has a problem with him, he might never get flagged, but he knows now the risk. I told him the risk that if that person decides their relationship sours and turns him in, he could end up in trouble both at the state and federal level. So what factors do you need to consider? Oh, look, it's control again. Oh, look, it's loss of profit again. Oh, the degree of skill. Did you have to train them, or do they know? What is your relationship? Are they a key aspect to your business? These themes are very, very similar. So there's the factors. They're still there. So who uses the factors test? Almost everybody else. That's a ton of different locations. But again, they're all very similar. Okay, now we're getting really specific. We have the ABC test, and you'll see how this evolves. So ABC, why is it ABC? I have no idea. Perhaps they no longer liked 1, 2, 3. So again, A is that the worker is free from control. Okay, yep, that still seems the same. B, the worker performs that work outside the usual course of the entity's business, so they're not a key aspect, they do what they want. And C, that worker does that thing perhaps for other people and does it. So that landscaper isn't only landscaping for you. That ceramics lady does ceramics at all of the local things. You know, she does it for the town, she does it for the other campground in town, definitely more like an independent contractor. So again, this seems like every other test, but they like to call it the ABC test. These are the lovely states that use the ABC test. Now, some of these states you'll have seen have come up multiple times. So Connecticut, as I pointed out on the other side, uses one test for workers' comp, whether you have to do it, and another whether that person would get unemployment or not. So if you're in some of these states, you have multiple tests to consider depending on the division of the Department of Labor we're concerned with. Was it unemployment? Was it workers' comp? So, way to make your life really, really easy. Okay, now we have the modified ABC test. So what this means is that they take pieces of it. So instead of ABC, they do different pieces. So who does that? Georgia only for unemployment, Illinois for workers' comp, and Indiana for unemployment. There is the AC test, which takes out B. They don't care about B in Pennsylvania, so they only care about the first prong and the third prong. And then conversely, Kansas and Maine only care about A and B and don't care if that person was doing landscaping at other businesses or ceramics at other businesses. They throw that C out of there. Still very similar. All right. Then there's the relative nature of the work test. So this test determines whether the work performed by that independent contractor is work that would otherwise be performed by your employees. Now that gets you in kind of a gray area. So if we go back to that front desk person, if you have other front desk people that are employees that are doing it, but you then also have someone who's a 1099, then that's work that's normally done by an employee for you, not just a random independent contractor. So then you get in trouble because the nature of the work is work that would have been performed by those employees of you and not something separate that would have done by an independent contractor. So again, the reason I keep using landscaping and ceramics is you might only have one ceramics person. So it'd be really easy to do that nature of the work test. You don't have anyone else running ceramics, so you don't have employees doing that. You don't need an employee to do that. It's a lot easier to paint that woman as an independent contractor because she's just her own isolated entity. And the way that you have to think about it in general is the more isolated that person is from your overall business and your overall control, the more likely they are to be an independent contractor. The economic reality test. Wow, there are so many tests. Good thing you don't have to memorize all of them. So the economic reality is, again, factoring what the economic reality of this is. So are you controlling them? How are you paying them? Do you have the right to hire, fire, and discipline them? And is are their duties an integral part of your business? Again, I feel like a broken record. These are all very similar, but every state considers them to be something different. And as we saw, Michigan had a different test for workers' comp. They used this one for unemployment. So depending on what state you're in, any of these tests apply. The normal work test, so there are two factors. Is there a contract with an independent enterprise? And is a contracting entity not in the same business, trade, profession, or occupation as the independent enterprise? So this ultimately is not likely to happen to us at all, but the best way to think about it is if you were that landscaping company and your employees were independent contractors, so to speak, you are in the business of landscaping, your independent contractor's in the business of landscaping, you're the same thing, you just don't want to call them employees. So it's very unlikely that this one is going to be something that happens. I think we'd have a hard time saying that the thing that you contracted with is in the same occupation as you, just because their occupation is so broad, but that's the normal work test. So penalties, what's the fun stuff? The Federal Labor Standards Act, so that's one federal thing. You may face a civil penalty, and you could also face criminal prosecution, so that'd be great. You misclassified this employee, you have to give them a ton of money, and now you have a criminal record. That's super awesome. I don't think that's a thing that people think can happen, but what they like to slap onto these federal things are criminal penalties, and you wouldn't want to get some kind of criminal record just because you misclassified an employee, and that's just under the Federal Labor Standards Act. So the IRS is also federal, and they have different penalties they can hit you with. So you'd face a penalty for not withholding your taxes or Social Security and your Medicare correctly, and they're not just going to ask you to pay it, they're also going to penalize you with a fine. So New York State is where I sit. I sit in an office in Albany, so I have a lot of that. So just to use an example for New York State, they don't have a specific definition for independent contractor. So what they look at in their labor law is just the quality of control. So they don't have any of those tests we talk about, but they'll still look at these random factors to decide if that person is an independent contractor. Again, they're very similar. Did I give them other benefits? Am I paying them through payroll? Do they have a fixed schedule? Do I care if they work for other people? That's how New York handles it. So again, very similar overall, but again, very different because they didn't adopt one of those tests. And then they, in New York, like to split it up like the federal government does. So the Unemployment Insurance Division does it completely different. We're not going to read all of this, but just so you know, they use the different direct controller supervised tests just in their unemployment department. So they have found that it's most likely an independent contractor if you invested in tools and insurance, if you bear the risk of the profit or loss, like what I charged that particular campground to hire me, oh, I made a profit or I made a loss, but that campground doesn't care, then I'm likely an independent contractor and I can work whenever it's convenient to me. All right. How do we limit our liability for all of these things? Yeah.
So you hire roofers,
Okay.
independent contractors.
Yes, absolutely.
And together you came up with a schedule of time.
Sure, that's fine.
That's not
Yeah, it's
scheduling their work, so to speak.
yeah, because they're telling you when they're going to come and they're available. It's different if you require them to come. So if you together were like, this is when I'm available, and they're like, from your availability, this is when I'm available, that's okay. But if you were like, you absolutely can only work on Mondays, I'll hand you the nail gun on Monday morning at 8 a.m., that's more what it is. Scheduling's a little weird, but it's more the requiring that repeated thing. So this is likely a one-off. I'm hoping you don't have roofing work every week. So this is a one-off schedule. Conversely, if it was someone else, say that landscaper, and you were like, you have to come every Wednesday for the entire summer, that's more when it's a problem. Okay, so you need to determine if you should be using that 1099 or a W-2. This can be an accountant talk. You can talk to a lawyer about if they're meeting those tests, but if you want to talk to if you're filing correctly with the government, that could be an accountant talk for you. You want to review your unemployment insurance and workers' compensation policies to figure out if you had to include them in those. And then you want to make sure that if you're misclassifying them, you remedy it as quick as possible to make sure you pay that back minimum wage and overtime requirements. And you want to look again at their day-to-day duties and make sure that you're hands off with them. All right, work campers. Billy and Jane work for us every summer. In exchange for 20 hours of work a week, they get their campsite for free. Is there anything I should be worried about? Yes, sorry. So the best way and how I'm going to start this is pay your work campers minimum wage. Run it through payroll, do the withholdings, do workers' comp. That's the best way to do it. Why? Because there's a couple things that you could think about. If they're really an employee, you need all of those things. And is that campsite excluded from their wages? Now, there's a couple ways to think about this. And I'm going to go a little off target because we don't need to go through the slides directly. So work campers. We've done it a lot as a barter system. And someone was like, hey, I just give them a campsite and they work for me. Is that okay? And technically, it's not. Because if they're not reporting that campsite as income, which they're likely not, then they're volunteering from you. And as I bored you with in the beginning, volunteers are a no-go for you. So if they're purely volunteering for you, then that's not allowed. Now, if they reported that campsite as actual income, you did a kind of barter thing, and that actually is acceptable. But I'm sure nobody's going, hey, that site, if I was a seasonal, was $3,000, so I reported that to the IRS as I made $3,000. They're not doing that. And additionally, that money would have to equate over the hours they worked as minimum wage. Yep.
If you hire your work campers and you have them fill out paperwork just as a normal employee, your tax form,
Sure.
this, that, and the other, and they sign like an accident waiver.
Okay.
Instead of having to put workman's comp on them, and they sign like a whole almost like an accident waiver. But you have all your standard employee paperwork done, and then when you pay them, you say you're 20 hours a week, and say if they do 30 hours a week, you just deduct their 20 hours for their campsite, and then pay them the remaining.
Yeah, you can, so there's a couple things there. So one, you can pay them and then they pay you back for the campsite. So whether that's physically handing them the money every week and then them physically handing it back to you, or you're withholding that money from them for the payment of that site, that is a way that people do it. The other piece is the workers' comp. That gets a little sketchy. So that's very state specific, but generally you should have workers' comp, because as much as workers' comp costs you money, it's also a protection. Because waivers, they like to throw out the window all the time, especially if it's a certain type of accident or a certain thing that they attribute negligence to you. So having them do a waiver instead of workers' comp is actually excellent for me, because what workers' comp does is kind of put a cap on what I can recover for that particular worker from you. If you don't have them through workers' comp insurance, that's when you see those 7-figure settlements. It's because I got to go outside the admin part of workers' comp and then just charge you with a big old negligence lawsuit. So that's kind of a risk you're taking not going through workers' comp. Workers' comp cropped up in this country as a way to both benefit employees because they knew they were going to get some recovery, and benefit employers because it capped the recovery that employee could get. So that is kind of a risk that you'd be taking in that scenario. You can conversely, if you want a really great workers' camp package, pay them minimum wage, give them the site for free, say that the site is a condition of their employment such that they don't have to report the site as income. But if you are doing it for a barter system, it's better to do the pay them, withhold money till they pay for the whole campsite. Yeah.
Do you have a contract form or something to that's been used?
So.
Or with work campers
So I'm going to be perfectly honest, when you're doing something with employment, it's better to give them an offer letter that just kind of outlines the offer and not a contract itself. And the reason I say that is most states, sorry if you're not one of those states, are at-will employment states, which means that I can fire you for anything that's like a non-discriminatory purpose, except if I put this whole contract together that might say that I promised you employment for the specific term, they'd read that as you circumventing the at-will, and you lose your ability to just kind of fire them for whatever. It's very similar. You don't want to put a whole contract together outlining something differently.
So we do the offer, we're in California.
Sure.
We do the offer.
Uh-huh.
And the site, we ended up in a lawsuit.
Uh-huh.
And it was the fact of the site not being tight enough.
Uh-huh.
We ended up with a disgruntled employee stuck on our site and had to look at that.
Yeah, so you definitely want to say as part of, in that offer letter, that the site is a condition of employment. You're right, you bring up another reason. All this financial stuff aside, so you can get them off your property when they're no longer in employment. Because I had something similar where someone said, oh, that's their housing, you can't just remove them. So yeah, you fired them, but that's their housing, so they can't leave. So you have to be really particular with how you frame them being on site if you're going to want to boot them. Now, most people, when they fire a work camper, the relationship has soured such that nobody wants to be in either spot, and I totally get that. But yes, you run into that scenario where no one's going to help you remove them. You'd have to give them, again, whatever the notice period is in your state, go through a whole eviction process when you thought just because you fired them, they're going to have to haul their camper out of there. So yes, you do need to make it clear that they're only there because of their employment, and otherwise they wouldn't be there. They'd have to leave. It's not their home, etc. Yes.
So if they're there as a condition of their employment.
Yes.
And you put a clause in there, something to the effect, if employment is terminated by either party, this site will cost you X number of
Sure, you can. I don't know how easy it will be necessarily to collect on that, depending on your state. You can put it in there. I call some things scare tactics. I mean, being perfectly honest, until I went to law school, I didn't understand a lot of things. So if I got a piece of paper and it said all these things, I'd think I was bound by it, even if I now know that if I brought that in front of the judge, someone would throw it away. But it does help illustrate the relationship. It is a defensive strategy such that if you went to court, you could say, you know, Sally agreed to this. The best way I found to do it is an offer letter. So you don't have a contract for employment, and then you have a separate employee handbook that they read and signed off of. And if you're in certain states that have other employee requirements, that's a good way to get those signatures. So for example, in New York, we have a lovely sexual harassment policy. If you have one other employee that's not yourself, then you have to watch these videos. I just watched them yesterday every year for this, and I have to sign off that I understand what the policy is, that it exists. That's something I'd check in the employee handbook. It's something I have to tell my New York campgrounds they have to do because one other employee besides themselves implicates that. You're not having them do that as part of your offer letter, but it's something with the employee handbook. That could also outline your vacation policies, et cetera. Still say it's an at-will, whatever, but set your expectations and those kind of things as well. Yes?
So what if we, so this is what I did this last year, I may have to change this, but, so I had some work campers, I brought them in at well over minimum wage.
Awesome.
And I just charged them $1.50 per hour work for their site.
Sure.
And so I just, so instead of paying $14 an hour, I paid $12.50.
Sure.
Is that legal, or?
So you're still above minimum wage in your area, so you're okay there. They're getting payment for their time there, and you're charging them separately. You think about it kind of like to
Net though, so then we're not paying FICA and unemployment and all that on 14, we'll pay on 12.
Okay. So you gave them a discount on their campsite. Is it?
No, I just give them a discount on their wage to pay for their campsite.
Got it. And their wage still covers. So, all right, so there's two ways to look at it. Technically, you're in, if we throw out the idea that they would have gotten other money, they're still well within the employment categories, so I can't see there to be a problem there. If they worked overtime, they'd be paid overtime at the 12 wage, if they whatever. I think that's likely okay. I'm not barred in every state. I can't tell you if it's absolutely okay, but I think you've colored it in such a way that it's okay. There's an understanding that this is what's covering the website. I think it's okay. The best way would be technically if we thought about it as separate transactions and that you paid them $15 and they paid you that back, that would be the best way when we talk about good, better, best. I think yours might pass the colorable test where it's still okay because they're still making over minimum wage and would get overtime and withholdings and taxed and yeah. Uh-huh.
Same job.
But they don't have a campsite?
They're not living on the campground. Those guys, you're paying FICA and all that.
Yeah, you're right. That does become a little more complicated if they're doing the same thing. The other part that would become weird is that where we talk about that condition of employment living there again. So if you have 2 employees doing the same work and one is a work camper and one isn't, then it's hard to say that it's a condition of their employment that they live on the campground.
Okay, so I'm gonna change this, I'm just gonna cater to paying 14.
I think, being perfectly honest, that is the cleanest way to do it. Pay them all the same, but people who live on there, charge them for the site. Whether that's a discounted charge off a seasonal rate or not, but they're living there as a condition of their employment.
Let me ask this one more question.
Sure.
Sorry, but let me ask this. There are campgrounds in this room and all over the country that trade out sites.
Ah, absolutely.
I mean, they trade out half or even
We did. I know. Like,
nobody's getting prosecuted, so why wouldn't they just do it?
correct. And that's what I told you, is most people don't until you do. So that's what I'm saying. It might not happen. It might take a couple years. I just like to flag what I think the next big risk in the room is. And because we're getting a lot of attention as campgrounds, and we have a lot of new players in the industry, and a lot of those are no longer mom and pops, they're big corporations, so it looks like bigger pockets. I do think that employment stuff is gonna spearhead more because we suddenly no longer we're just the family that owns the campground. It's like there's a big conglomerate. Because you hear people say all the time, like the disgruntled Walmart worker who's like, I didn't scan that, that's okay, screw Walmart. Like, the bigger the corporation is, I think the farther removed they are, and that's why I think you're gonna see more kind of employment stuff.
So I'll bring up something. We pay well over minimum wage for about San Francisco.
Okay? And you're in a state that has lots of laws.
Yeah, like what you said on the deeper the pockets, the more.
Uh-huh.
We're in lawsuits constantly.
Yeah?
It doesn't even faze us anymore now. And the trip falls and everything. Susie Q, who's 90, who's somehow behind my water tanks, but.
Yeah, yeah.
Anyways, it's a retirement program. So when we do well over minimum wage, but we give free site, or it's not free exchange for the fact they do the nightly lockup.
Uh-huh.
We're three generations, and this has come through the history, and my husband and I go to war over this fact, that I tell him that is going to, excuse my language, screw us in court because of the fact that we should keep it clean, and that's not clean.
Yeah, absolutely. So again, clean is great. There are tons of campgrounds who haven't done it. They got into the industry and out of the industry without it ever being a problem. You just might end up being the unlucky one. So that's why painting those standards. Now, what you bring up actually colors something a little bit different for me. So when we were talking about how he has 2 employees doing the same job, if that one employee who has a campsite does an additional task, like the night lockup, then you could probably color with a straight face that it was a condition of employment that that particular employee, even though most of their job was the same, they had additional duties that made it a condition of their employment to stay on the campground.
So then it would be okay in the fact that nightly lockup is really the only difference of those jobs. We pay them both the same standard rate, overtime, everything.
But the one person, because they do this additional, so they bartered that site for it. So as long as you could say the hours they'd have to do for the night lockup equate to the amount of money that that site would be overtime. Yeah, I mean, that's the thing. So you'd have to think about it. If our site is $3,000, okay, if our site is $3,000 and over the course of the summer they worked X amount of hours, if I divide that amount of hours into the campsite, are they still making minimum wage for that time? So that is, that's what I said. There's the perfect way to do things, and then there's kind of what we've been doing. Yeah.
If we are on a very small campground,
Sure.
we have 4 work camper sites, and I hire couples. Now, couples in today's world can take on more tasks,
Absolutely.
makeups. We have a
Cleaning and front desk, landscaping it.
married.
Oh, yes. Gotcha.
We got all sorts of.
Roommates, whatever. Yep.
I had to release several employees because one of them, not the other one of them was not doing it.
Absolutely.
One was being rude to my guests, and
And now you are firing this other person because of their.
both of them.
Yeah.
How can I best protect myself?
Yeah, you're right. That is kind of a complicated one because you ended up having one relationship with two people, essentially. But they're still individuals in the eye of the law, so you technically should have had two relationships with them. So again, having the campsite being a condition of employment, et cetera. If you're an at-will state and you didn't paint anything as something different, if you didn't give them a contract saying that they were definitely going to be there for that time period, then you can technically fire that other person just because, like,
I had a gay couple that tried to accuse us of,
discrimination.
even though I had to do about the rudeness.
Yeah, so this is what I call the paperwork conundrum. Nobody wants to hold on to records for eternity, but this is where you start keeping records. So you're like, you did this, you're insubordinate, you put other people's safety in jeopardy, you paper up. I mean, at the very core of anything legal related, poster child for law, is having a lot of paper such that you could defend yourself. Nothing keeps you from getting sued, right? You're gonna get a lawsuit if you're gonna get a lawsuit. It's more about how much do I have to support my version of the events. And that goes for slip and falls, that goes for employee, that's everything. Yeah.
So we had a
Oh.
couple that we fired one,
Uh-huh.
kept the other,
Uh-huh.
married couple.
Yeah.
Condition was you can stay, but he has to be off our property.
Yeah, I mean, you could do that. I would be upfront. Yeah, I mean, some people do that. Like, I had a couple that they let them stay. The other one went and got a job at Home Depot.
We made him go off the property.
If it worked for you.
Yeah, he couldn't stay on the property.
Well, I'm surprised the other one stayed on the park then. Some relationship there. Let me grab you.
Would it make a difference if your offer letter was to the couple versus to the individuals?
So, I mean, yes, we could say the paperwork, we hired you as a team, one part of the team does it. Under the eyes of the law, you're still kind of separate people. You file separate you're different people, you have different social security numbers. Technically, you're still separate entities. Again, that would be, they turn around and sue you. We understood that it was going to be a double relationship. If it wasn't working, you both have to, like, this is what we understood it to be. You paper it up in that regard. Technically, they're still different people. They could come at you separately for that. You could say you were discriminating against partner A and not partner B because you weren't discriminating necessarily against them as a couple. So there are a lot of pieces there. Yes, there's employment practices and liability insurance. Yes, that's a good one.
Was where I was going. So if you have a couple, and we've not ventured into the area yet, we're looking at that. Would you have two separate offer letters?
You could, yeah. I mean, to make it really clean, you could. You'd be like, this is what I understand Billy's gonna do. This is what I understand Sally's going to do. You both understand that as a condition of your employment, we are having you on the site. Should your employment cease to whatever. Yes, technically you can. Have I ever seen that done? No, I see offer letters done jointly all the time because they're a couple, so to speak, whether it's two roommates, whatever, but they're coming together as two people, so it usually is somewhat of a package deal. It's very hard to fire one person and have only one of them on your property. Kudos to you. I don't know how you convince that. Good. Yeah. She was going to have to cover it all by herself. Yeah, I'm surprised that you did. Look at you. Must be a very firm lady that you got what you wanted. As I briefly touched on before, if we're doing all of this, you might not be running them for workers' comp. Please, 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 please do it. Your insurance agents will tell you the same thing. Especially if they're maintenance employees. They get hurt in all sorts of fun fashions. Nail gun through the hand, didn't know how to use a saw, fell off a ladder, slipped off a roof and blowing it off. Please, 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 please just put them through workers' comp. I would love to sue somebody who doesn't do workers' comp. I get lots of money that way, but don't. Please, 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 please use workers' comp. Okay, so what are other issues? So we talked about all of these misclassification of employees. That's what I'd call the previous section. So there's those three types of employees. Those are three types of ways you could be mishandling their employment. Are there other things? Yes, there absolutely are other things we can get in trouble for. Of course there are. So background checks. A lot of people are doing them, and they're doing them both for their employees and their campers. So I'm going to touch on briefly just to give you both of them. Do them if you want to. But if you do them, either use a company that you know is doing everything correctly or don't. And what I mean by that is that you need to get the specific permissions before you run their background checks. So you need to make sure either that company is getting the specific permissions or you're getting the specific consent. And then you have to know what you're allowed to do with that information after you get it. Now that's different both at a state and federal level. So you're going to have to look in and check in with your state to see what you're allowed to do. So in some locations that's, I'm not hiring you because I found something in your background check, and that's all you have to tell them, but you have to at least tell them that. And where, you can't just be like, I'm not hiring you, or ghost them. You have to actually tell them that you're not hiring them because of something you found in their background check. Or I'm not letting you stay here long term because of something I found in your background check. So that is something to kind of know and think about what you're doing with that information. Additionally, and this is my favorite poster child for this, there are certain laws where other things are embedded. So I have a campground in Massachusetts who wanted to remove a long-term guest because they found out that one of that couple was a sex offender, a registered sex offender with a minor violation charge. So there's no way they wanted that person near playgrounds or anything else, and they wanted to remove them. In Massachusetts, not under their regular discrimination law, but under their sex offender law, there is a part of the statute which says you cannot discriminate against a sex offender. So that campground got dragged to housing court because they were taking their housing away. We got that one thrown out. We got dragged to court over discriminating against a sex offender and had to say that we weren't discriminating against them. They were being removed for other reasons. Now, if you had only looked at the regular discrimination law and you know what you think and what feels right, you wouldn't have realized that that was something someone could have dragged you to court over. So do keep in mind that in some states, if something came up in a background check, you might not actually be able to use it against them. So be very careful what you're doing with information, and if you're going to use it for something, make sure you're allowed to do that. Yes? Any sources? There are a lot of companies, I don't know if there's one here, that'll run it correctly. If you search background check law in your state, usually it'll pop up with the requirements of what you're supposed to do in your state for that. Is that what you mean? Oh yeah, so there are some companies, I can't remember the top of them off my list, but there are definitely some companies. I think there's a specific company that's now doing campgrounds. Yep, camp background check. So they do the first half of it correctly, for sure. They'd have all the consents correctly. I'm pretty positive they don't take any liability for what you do with that information, so that's still on you. So they'll do the first half of it correctly, but if you misuse that information, you can't go back and recover from them. I'm sure they have a lovely disclaimer. Yeah. Yeah.
Apply for that.
Yep.
And we ask that specific question to allow us to do a background check. And then we also ask what their background is.
Yeah.
And if they give us that information without us doing a background check, and we say, stay with this.
So you are in a little bit of an area. They self-disclose then, you didn't find it. If it's something that you could, so technically at the crux of it, you can refuse people for anything. So like at RVIC last week, we did this whole talk about EV, and someone was like, can you refuse somebody if they come in with all this electrical stuff and you don't have the supply? Absolutely, you can. You can refuse people from your business as long as it's not for a discriminatory purpose. So I can't refuse you from my business if vests are a protected class and I don't like people with vests, right? But if you told me all these things and refusing service to you for those things is okay as far as the law is, then I can't. I just know them and I don't want you there. Just like I knew you were bringing all these things into my park and I don't want them there. I can refuse you for that because I'm not discriminating against you. Yeah. Oh yeah, so if we're talking about actual was I hauled to jail over this, yes. But that again, that goes to what you're allowed to discriminate people against from. So in some places, just because they brought you before court on that, if they didn't actually find you guilty, then you can't use that as a thing. Thank you, Micah. All right, so OSHA, the reason I bring this up is that COVID meant that we cleaned with a lot of different things last year. And if you did not properly train the person who was cleaning with that or provide the specialized equipment they needed to clean with that and they got hurt, you could end up with an OSHA violation. What's one way I saw this in the not COVID period? Someone had an indoor swimming pool, so their whole system, the whole machines, the filters, the chlorinator was all indoors. So when that person was doing chlorine, they didn't provide them a proper respiratory mask, and supposedly this chlorine blew back and it affected his respiratory system forever, such that he sued a big lawsuit, and the state OSHA in that state actually came in and smacked this facility for their indoor swimming pool for not providing training or all of that, and they had to pay this gentleman a lot of money because they had him doing a task without providing the specialized equipment or training. And the reason I think this is an issue is because we brought in all these new kinds of equipment and chemicals with COVID, whether it was foggers or whether it was just harsher chemicals, that if there was a standard for those and you're having an employee do it, please make sure that you're providing them whatever they need for that to be safe, such that they couldn't report that you weren't meeting OSHA requirements. Or as I say, do it yourself, because you're not going to sue yourself. But that is something to think about. A hostile work environment, what do I mean by that? So that sounds more, I think people think of this more like in an office setting, but the way that I've seen this happen is your entire maintenance staff is dudes except for Sally, and they make a lot of off-color jokes all the time, and they make her feel really uncomfortable, and frankly, it arises to the point where it makes her feel like she can report you for sexual harassment. So that is something that you need to think about. I've seen it in factory workers. I've seen it when it was all the same gender, but one person felt particularly uncomfortable. You just need to be very careful, and the onus is on you. You have to provide that safe work environment. So be very careful and make sure you have a policy that if Billy is saying these off-color things, you put the kibosh on it and it's not happening anymore.
I think campgrounds
What's that
could be
mean?
where your campers are also included in that if the employee
Yes, makes them unsafe.
feels intimidated or
Yeah, your campers can't make them unsafe either, or in a broader spectrum, your customers can't. So I can't put my lovely marketing person in the corner in such a place where a bunch of people would be attacking her all day long. That would be putting her in a
we have
bad
a
work environment.
desk and a camper who's, I'll call it personal proximity,
Uh-huh,
and we had to limit the being able to come in the store
yeah.
because it fell under this.
Ultimately, you have to provide your employee a safe working environment, and that could be verbal, it could be physical, it could be from their coworkers, it could be from your campers. So yes, that is something that you have to worry about, and it's a very easy complaint form in most states. They don't need an attorney to file against you, so it's a low barrier to entry for them to come after you. Yeah? Yeah?
On the other side.
Uh-huh.
Kind of familiar with it. Say, we have an employee, we had one, we had a tree limb.
Sure. Mm-hmm.
Say they take the ladder out to,
Okay.
have a tree limb,
Yeah.
okay? Well, according to OSHA, you got a one-time ride on the ladder to go up and tie it to
Mm-hmm.
the tree or whatever.
Yeah, they have all the specific requirements.
And then you had to come down, hang a yo-yo, whatever. So, and then after that's performed,
Mm-hmm.
one step, you're supposed to be in fall gear.
Yeah.
Hang over the person.
I know, it's crazy.
So should we have to go through all that with Dad and then cordon off the area where we're doing the limb?
Technically, if you fall under those requirements, you would. Did it happen? Did my father go up in a bucket truck without any harness or anything? Yes, absolutely. It happened all the time. Did other employees do crazy things and it wouldn't have been OSHA things? Yes. Did it ever come back to bite us? No. Could it? Yeah.
Well, that's what I'm saying, so there's different requirements, some places require 100% time, you have to have one
Yeah.
lanyard together at all times, or if you have a single lanyard.
Yeah.
Who says to be 100% time? That's what I'm trying to think, because I'm trying to cover us.
You got a state level, usually. They're the ones who would enforce. So in Vermont is where the pool story I was telling out. VOSHA in Vermont is the one who came after this group. So it's likely whatever your state is promulgating. Yeah.
I'm the proud owner of about a half dozen OSHA violations in previous years. But the federal OSHA law is very clear on fall protection. You
Yeah.
can only do it
Yep.
The state cannot be below.
Correct. They can be more restrictive. Yeah, that's generally law in general, actually, so that's a good thing to know. The federal sets one standard. States can't suddenly legislate and make it loosey-goosier. They can only make it more restrictive. And if you're in a place where it goes federal, state, town, the municipal is the same thing. They can always be more restrictive than the state. They can't be less restrictive. So depending on where you're located, as you go down that puzzle piece, it becomes more. Again, there's lots of OSHA violations happening in a lot of places. It might never come up. It could come up.
For your safety meetings, though, document your safety meetings, do not ignore that.
Yeah, the more paperwork you have, the better if something happens. But that's what I said, it can happen. There's specific leave laws if you have more than 20 employees. Now, it used to be that I wasn't concerned about a lot of this stuff because a lot of campgrounds are exempt because they had so few employees. But as I watch things change and I watch people be more passive, they end up having more employees and suddenly find that they're implicating more labor laws. So be very careful and figure out what thresholds for some of those laws are in your state, because one more employee could change everything else that you're doing. And we talked about the at-will employment and agreement. An exempt employee, this I've seen come up a lot. So there's a federal level for a salary employee and there's a state level. So for example, I think the federal level is they're a salaried employee if they're like $30,000 a year and they have X amount of control. In New York, we went even higher. You have to pay that employee $48,750 a year, and they have to be completely independent such that I'm not controlling them for them to be considered a salary employee that I don't owe overtime to. Now, we had this come up. There was a park manager. They paid them at the federal level. They didn't realize that the state level was any higher. They're in big trouble. They're quickly trying to kind of settle with this employee before they go to the Department of Labor to pay them that additional money that would have been overtime and such as that, so they don't report them. Just because you say someone's a salaried employee doesn't mean they're technically a salaried employee. Just because you say someone's an independent contractor doesn't mean they are. So if you think you're off the hook for overtime and all of that because they're a salary employee, please make sure that you're meeting those income thresholds and those independence thresholds such that they couldn't report you. And this is literally a campground I have this summer fighting that right now. So it is something that has come up in this industry. So be very, very, very careful. Yes? Yeah, so it depends. So we saw with some things, like I think about maybe even the PPP loan, they had some exemptions for seasonal employees. Again, that's gonna kind of go to your state. Some states have really good legislation about seasonal employees, some people don't. And if there isn't a specific carve out just because you're a seasonal business, then those laws still apply to you, even if they're not helpful. Like paying a salaried employee $48,750 for an entire year, it feels a lot better than paying them that for 6 months. But I'd still stuck at the same threshold. I still have to pay them that to be considered a salaried employee. Yeah, so that's unfortunate. Yep. Yes. Federally, absolutely. State, I'm pretty positive, absolutely. I'm not in every state, but I assume so. And that's why a lot of people try to get out of that with the salary employee, which is why it's now come up that you need to make sure you're meeting those requirements. And just because you met the federal level doesn't mean you met the state level. So be very, very careful. So we talked about all that. Lodging as wages, we touched on when we did work campers, so we don't have to go through that. These are states that include those in it, lots and lots. And then these particular states have express rules against including lodging costs in your wages. So that's something to keep in mind. But I think we are at the end. It sounds like everyone else is wrapping up there. Am I at the end? Yeah, okay. So that's that. I'll be here all week. I'll be at the trade show on Thursday. Feel free to find me. I have business cards with me right now. You can shoot me emails. Even if I can't help you in your particular state, I can kind of hopefully lead you in the right direction. And I love interacting with you guys, so feel free to bug me.